administrative law is a part of public law, and it is having the importance due to constitutional law, which is also a public law. And what exactly administrative law as it is was defined by the English jurist. The first one was Sir Ivory Jennings, who defined it as law relating to administration and how it determines the organization, the powers and duties of administrative authorities. Here it is being criticized by his definition of administrative law for not explaining the manner of exercise of power, the control mechanism, and for not differentiating between administrative law and constitutional law. And the criticism was rendered by Professor A.V. Dicey, one of the most important English jurists, who defined it that administrative law determines the legal status and liabilities of all state officials, their rights, so also the rights and liabilities of private individuals in their dealings with public officials, and the procedure for enforcement of those rights and liabilities. His definition left authorities like public corporations, so does not provide the procedure to be followed by administrative authorities. And lastly, he is being silent on the powers and functions of the administrative authorities. So, the next definition comes from Professor K.C.Davis, an American expert who defines it as the law concerning to powers and procedures of the administrative agencies and the law governing the judicial review of administrative actions, but he left the control of Parliament over delegated legislation and the discretionary functions of the administrative agencies. So, the most important definition of administrative law was given by an Indian professor, Prof.Upendra. According to him, administrative law is the study of the pathology of power in developing society. So he stressed emphasis on the rule of law in society, the holder of public power, and the authority are accountable for their action. So, to find out a perfect definition of administrative law, which would be universal and uniform, so we should find out the set of rules expressed by statutes implied in the prerogative to fulfill the object of public law, so it touches administrative and quasi-administrative agencies. Accordingly, it includes legislation, judiciary, and practical application of rule of law. So, the acceptable definition shall be, it is that branch of public law which deals with organization and power of administrative and quasi-administrative agencies, the procedure to be followed by them in the exercise of their powers and functions, the method of control mechanism, and the remedies available to the persons in case of violation of their rights. The structure of administrative law includes statutory law, administrative rule-making, administrative circulars, policy statements, administrative directions, memorandum, and resolution. So, as a branch of public law, it primarily deals with the relationship of individuals with organized powers in their day-to-day functioning of administration, and quasi-administrative agencies must follow the principle of natural justice. Administrative and quasi-administrative authorities are concerned with rule-making action, adjudicating action, rule application actions. Further, it includes the control mechanisms, which are the following. Number one, higher administrative authorities. The second one, the courts exercising ordinary judicial powers. Number three, the writ petitions. Number four, public opinion and mass media. Number five, the institution of ombudsman and investigating agencies. Number six, the NGOs and organizations fighting for the cause of consumers, liberties, freedoms, and rights of individuals, such as the women and children, weaker sections, scheduled castes and scheduled tribes, bonded and forced labor, prostitutes, prisoners, etc., are the control mechanisms for the arbitrary use of powers and functions of administrative and quasi-administrative agencies. So, these are the very fundamental issues relating to administrative authorities or agencies, and as these administrative authorities and agencies are dealing with one part of public law, so they must perform as according to the principles of natural justice and how to deliver those natural justice for those individuals and citizens whose fundamental rights or natural rights are being guaranteed under the constitution of a state. So how this functioning of administrative authorities and their working is being described and defined by those jurists and authorities which are reflected on the following topics which we will discuss in our next videos.